we'll begin. Thank you guys for coming. I know it's early in the morning. Those of you who had to fight through the Indians traffic to get here as well, I'm really appreciative. My name is Tim Webster. I teach international and comparative law at Case Western Reserve, and I'm glad to have the opportunity to come to the City Club and talk with you about some of my current research on World War II litigation. And you may be wondering, with all the craziness that's going on in our own country, why something as abstruse and as ancient as World War II could possibly be of interest or possibly be even relevant in today's day and age. So let me begin with this slide, just to give you a sense of why this still matters. And so I see my student Wonbo here, so I'm not going to ask him, but I would like to ask other people in the crowd, because Wonbo knows who these guys are, but we're not testing him today. I had to test him all year in international business transactions, so I'm going to let him off the hook today. But others of you, I'm wondering if anybody here in the crowd can tell me or tell us who we have in these two pictures. We got two pictures, one on the left, one on the right, and who do we have here? So on your right, let's say, the guy in front of the large flag with the red dot, who is that? That is Abe. Yeah, and do you have an idea what he's doing there? At the Holocaust Museum? Close. So that is Prime Minister Abe Shinzo, right? Current sitting Prime Minister of Japan. Anybody else have a guess as to what he is doing?
Was it one of the quasi-apologies for Japanese war crimes?
Exactly. Yeah. So both of these slides were taken in August of 2015, so a couple of years ago, a year and a half ago, a little more. And both of them are around the commemoration of World War II. And so on August 14th or 15th, Prime Minister Abe made a quasi-apology. I couldn't have stated it any better myself, offering some remarks, some remorse, a bit of regret about Japan's prosecution of World War II. And this is a decennial ritual that Japanese prime ministers make on the anniversary, or the decennial anniversary of World War II. And you can see his face. He's bowing ever so slightly, right? It's not a full 90-degree, deeply respectful bow. It's kind of a, it's a little bit of a, 10, 8-degree bow, suggesting that he is somewhat apologetic, although even the term apology was one that was very deeply wanted, but he never actually used the word for apology. I was in China when he made this statement, and I got to read the Chinese press's account of it, and so they said, well, he expressed remorse and regret, but it wasn't a true apology. And so the Chinese and the South Koreans as well, who very closely monitor these things, were not thrilled by Prime Minister Abe's quasi-apology. So yes, we have Abe making some remarks and bowing somewhat in August of 2015. So that's the slide to your right. What about over to the left? Who do we have there? I'm sure you recognize at least one or two of them, hopefully, maybe all three. Putin in the middle.
Is that the Chinese president to the right?
Yes. Xi Jinping is the Chinese president.
South Korean president.
Yes, exactly. And then the woman in the yellow jacket is now jailed Prime Minister of South Korea, Park Geun-hye. And any idea what they're doing?
Another World War II conclusion, commemoration.
Yeah, do you know where they are?
Moscow?
Close. Actually, geographically not close, but close insofar as they're in one of those capitals. Beijing. Yeah. And they are watching a military parade, showing off all of China's latest kit. And President Xi is the host here, and he invited Putin, and he invited Park Geun-hye, and he invited a number of other world leaders, including Obama and François Hollande, etc. But only Putin and Park Geun-hye actually showed up. Actually, Ban Ki-moon the former Secretary General of the UN, was also there, although he was not here for the photo. So here again, we see how important World War II is. It was a cause, a major celebration, if you like, for China. Down the streets of Beijing were trotted out ICBMs and tanks and all kinds of other military hardware to celebrate China's victory over Japan in 1945. That's how it's currently being constructed. Now, I think these images are also important because they show that this is important in the present era. You have the national leaders of these four countries here. But you also have an interesting sort of division of who is on whose side during World War II. During World War II, the Russians were not at all happy to be seated next to the Chinese. Right? Obviously, they were allies. But during the Yalta Conference, for example, the Russians, not Yalta, excuse me, during Dumbarton Oaks Conference here in the United States, the Russians said, yeah, we'll show up, but we're not going to be seated next to the Chinese. They're two-bit players. They're junior varsity, whatever it is. We don't want to be anywhere near them. So the U.S. actually had two different conferences, one with the Russians and one with the Chinese, because the Russians were unwilling to be seated at a table alongside the Chinese. So that's one kind of revision from the way actually World War II was conducted. And then secondly, you have Pak Geun-hye, right? And as those of you who know your history would know, Korea was actually a colony of Japan at the time. And so to be historically accurate, you would have the Korean leader actually next to Abe, right? Because Korean soldiers fought on behalf of the Japanese Imperial Army and died and did a number of other things as a colonial state of the Japanese Empire. So again, this is one of many, many, many reinterpretations, if you like, of World War II in the contemporary era. So what I'm going to do in my talk today is talk about 100 or so lawsuits that have been unveiled over the past 25 years in Japan and in East Asia more generally about World War II. But again, to sort of bring you guys in and understanding that probably many of you, with one or two exceptions, probably may not know a lot about East Asian geopolitics, I thought I would bring up this, which is something that probably you are familiar with, which is what has since been called Holocaust litigation. And so this was a number of lawsuits filed in New York, filed in New Jersey, filed in Bonn, filed in Vienna, concerning a whole range of World War II activities, things including slave labor, the looting of art, including this piece by Gustav Klimt, and the seizure of assets by numerous Swiss banks. And so this stuff, these cases were filed in the mid-90s, and the lawsuits themselves weren't actually successful for the victims, whether they were enslaved or whether their art or their assets were seized. But what it did do was catch the attention of a number of members of the Clinton administration who then worked with both the German government and the Swiss government and the Austrian government and a number of the corporations themselves that were complicit in this, right? The banks or Ford Motor Works, right? One of the companies that used slave labor in Germany, Siemens, and so on and so forth, to set up large funds, large settlement funds, that both the German government and the German corporate sector, the Swiss government and the Swiss corporate sector, fed into and then dispersed those funds to various victims of World War II. So this is, again, something that you may have read about. And this, I would submit, is one way, perhaps a better way, of resolving this than through seriatim, individualized litigation. But this, of course, requires a lot of political will, requires a lot of coordination, and we haven't seen a similar dynamic unfold in East Asia. So let me now turn to East Asia and talk about some of the many, many different judicial interpretations we've seen of the war that have taken place in East Asia. So again, most of you are probably familiar with Nuremberg. There was an analogous effort set up after World War II to try the big fish in the Japanese government, Japanese military. And so you had the Tokyo Tribunal, or Tokyo Trials. which prosecuted 24, 25 of the main players, the big players in the Japanese war effort. Many of them were tried. All of them were tried. Many of them were convicted. A few of them were hanged. Many of them were imprisoned for 10 or so years, and then their sentences were commuted. So that's one effort. A second effort is a number of lawsuits filed in Japan by victims of the war. And so a couple of these are, I think, significant. One is called Shimoda. Shimoda lived in Hiroshima. He got radiation sickness because of the bomb, and he sued the Japanese government for medical treatment. He said, look, you waived my claims when you said that all nationals give up their claims against the United States government. So you, Japanese government, have to pay me for the medical treatment that I now need to pay for. The Japanese Tokyo District Court said, no, sorry, that's not the way it's going to go. Although this decision is important for, among other reasons, recognizing that the dropping of the bombs, both in Hiroshima and Nagasaki, were a violation of international law. That's something that we in this country have discussed and deliberated about. This is one judicial decision that actually recognizes that, yes, the bombing there violated international law. It was essentially indiscriminate. You killed 100,000 people, and that wasn't specifically targeted enough, narrowly targeted enough to advance a significant military objective. Therefore, it violates the laws of international humanitarian law. So that's one case. Slightly later, again, you have, in this case, Taiwanese soldiers. Again, I said before that Korea was a colony. Taiwan was also a colony of Japan in the early 20th century. And a number of soldiers from Taiwan served in the Japanese military. After the war, though, they lost their Japanese nationality and could not access those pensions and medical benefits that Japanese soldiers got. And so they sued. Again, Japanese courts were not particularly helpful there, but the ultimate result of that is that in 1987, the Japanese Congress, passes a law that gives about $20,000, of compensation to these 13 soldiers, the plaintiffs in the lawsuit, as well as others who are similarly situated. Right? So one of the dynamics here is file a lawsuit and hope that you get enough political traction that you will get a law to offer some kind of remediation. That's another. Yeah, go ahead.
I assume 20,000 would be just a fraction of what a Japanese soldier would have gotten over time in government services post-1945.
Yeah, it's a great question. I don't actually know. Yeah, I'm going to have to punt on that one. But the thinking was, well, this is going to cover at least some of the medical expenses that you would have incurred as a soldier, and the other sort of compensation money they have allotted for Japanese soldiers. So that's another sort of piece of this judgment or rejudgment of World War II. And then what I'm going to spend most of the rest of the time here talking about is this big spike in litigation we've seen over the past 25 years. Again, mostly in Japan. There have been about 100 lawsuits filed in Japan. They've also been filed in China, in the Philippines, in Korea, and even in here in the United States. So people say, okay, why 1990 do you have this sudden uptick in World War II litigation in Japan? There are a number of reasons. I'll talk about a couple of them here. I think one significant one, I think that lawsuit brought by the Taiwanese soldiers was certainly helpful. You also have the death of the Showa emperor, or whom we call in this country Hirohito. In 1989, you have that. You also have the fall of the Berlin Wall. And there's a lot of re-examination of the Cold War and World War II generally by academics, by lawyers, and so on and so forth. So this allows people to sort of look back and say, did we actually do a good job either remembering or repairing those who were harmed during World War II? And another, I think, important part of this is that, as in any post-conflict situation, you have a lot of denial, a lot of silence. And in 1990, you have the first comfort woman. Are people familiar with the term comfort woman? many of you are. For those of you who don't, during World War II, and actually going back into the early 1930s, the Japanese military would abduct, or in some cases tricked, or other cases just forcibly grab women from Japan, but also from Korea, from China, later from Taiwan, and from the Philippines, and put them in what they called comfort stations, all right, in Japanese, ianjo. And these were the women who were charged with providing comfort, i.e. sexual services, to members of the Japanese army. And so, unfortunately, I think this term has spread into English, and so now we call them the comfort women, although some people have said, well, a more accurate term would be something more like military sex slave or a rape victim or things like that. There are a number of ways. And obviously, language here is important. I'm just going to use the term comfort women because it's the one that I think probably most of you are familiar with. Now, after the war and throughout the 70s and 80s, the Japanese government basically denied that the comfort women ever existed. They said, nope, just a myth, didn't happen, fake news, whatever it is. And so that sort of that system didn't exist, and there were no women who were actually forcibly abducted and brought to these Japanese military stations throughout the, at the time, Japanese empire. And in 1990, you have a Korean comfort, a former comfort woman named Kim Pak-sun, who steps forward and is, as far as I understand, the first woman after the war to come forward and say, yes, I was a comfort woman. I was abducted and raped 20 to 30 times a day by members of the Japanese military, and this actually happened, right? And she then was one of the first people to actually sue the Japanese government for subjecting her to this kind of treatment. But her public announcement of that and the fact that she then sought legal help and tried to make and did actually sue, I think was another reason or another impetus in people's reconfiguration, rethinking, revising, reimagining of World War II. There are other things as well that we can talk about in Q&A, but these are, I think, are three of the important reasons as to why this is happening now. Okay, so now let me just give you a sense of what's been going on, again, in Japan, but also around the region and even here in the United States. As I said, you've had 100 lawsuits in Japan. You've also had them, as I said, brought here in the U.S. and other Asian countries as well. And they are suing both the Japanese government and roughly 24 Japanese corporations, things like Mitsubishi, Mitsui, Sumitomo, these large conglomerates or zaibatsu, that use their labor either in munitions factories or plane factories or mines or stevedoring operations at ports, things like that, for slave labor. So there's different sort of tranches of this, let's say. I divided up into three different categories. One involves what I call systems, right? So people, the comfort woman was a system. It was an organized, orchestrated policy by the Japanese government with the help of the Japanese military to abduct and then send women at first in Korea and China, and then all over, again, at the time in the 1940s, the Japanese empire to serve or to service, let's say, Japanese soldiers. That's one of these systems. This forced labor prong, again, which has been where a number of these Japanese corporations have been sued, has, again, probably yielded 10 or 15 different lawsuits, again, against these major Japanese companies. Unit 731, has anybody heard of that? Go ahead.
They just did awful, inhuman scientific experiments, often on living subjects.
Yeah, so this was a medical experimentation research center that the Japanese army set up in Harbin in northeast China and Manchuria to conduct a whole range of medical experiments on live Chinese subjects, right? So they would freeze their arms and then attack it with a sledgehammer and see what happened. Well, the arms would break, right? That's what happens when you freeze things. They also subjected them to anthrax, to cholera, to gonorrhea, to syphilis, to a range of contagious diseases. And they also developed other chemical weapons that they then used in the war against China in places like Ningbo and Changsha. So again, that was another system. That was something that the Japanese government had set up to conduct medical and scientific research. Finally, and this may be the piece you're most familiar with, it has been lawsuits brought, again, both in Japan and in California, for example, by prisoners of war, both American prisoners of war and prisoners of war from the Netherlands, from Australia, from Britain, and so on and so forth. So this sort of tranche of litigation I call systems. A number of these lawsuits have also targeted specific events, things like the rape of Nanking or the Nanjing Massacre, again, something probably many of you are familiar with, and some other relatively large-scale and indiscriminate bombings in places like Chongqing and in Shanxi province as well. So again, individual victims from Nanjing or victims from Chongqing have come forward to suggest or to say, to argue that these killings, these large-scale massacres, violated international law and Chinese law and Japanese law of the time. Finally, and again, we've seen some of this already, access to social services, things like pensions for soldiers, medical treatment, those sorts of things have also been the subject of a number, a smaller number, maybe 5 or 10 lawsuits as well. So this just gives you a list of the different types of lawsuits we're talking about here that have been filed, again, as I said, over the past 25 years or so. Now, let's talk a bit about the results. As you probably won't be surprised, again, based on what I said about the Holocaust litigation, that Japanese courts have not been particularly sympathetic, and they've deployed the defenses brought by the Japanese government, one of the defendants here, or Japanese corporations, and have used, again, standing law to say, well, even if all that stuff did happen, we are excused from legal liability for the following reasons. With regards to the state, the most important thing here, of course, is sovereign immunity. We are the state can do no wrong. Only after the end of World War II did Japan put into place a state compensation law whereby someone who was harmed by state action could sue the government. And so what these courts have said is that law, the state compensation law, only came into effect in 1948. This stuff all happened in the 30s and 40s, and so there's no retroactive law. Sorry, you can't. The government here is not going to be liable. They've also used standing arguments to say, well, even if there was a violation of international law, this is something that states talk about, states deal with. Individuals, people can't stand in for states and sue other states, meaning if you have a problem, talk to your government, talk to the Chinese government, talk to the South Korean government, or the Philippines government, and have them talk to us. Right? So by the standing issue, they say, well, individuals, even if they were brutally victimized, don't have standing to bring these kinds of cases in Japanese courts. So that's how the government has sort of got off the hook, let's say. A second defense used by both the government and the corporations is, look, statute of limitations. Right? So these are primarily framed as tort actions. Right? You did an act that caused harm to me, and as in the United States, as in any legal system, there's a statute of limitations. In Japan, it's 20 years for these particular acts. And so by 1990, 1995, 2000, 2010, when these lawsuits were brought, obviously the statute of limitations has run. Right? So you can't bring these cases. And again, it's primarily been the corporations that have used those defenses, and by and large, they've been successful in doing so. A third defense here is to say, we've already done this, we've already taken care of these claims. We had a series of post-war treaties between the US and Japan, the joint communique between China and Japan, a 1965 agreement between South Korea and Japan handled all of these claims. And in those different agreements, the state, whether it's the United States or China or South Korea, has explicitly stated they waive all claims of their nationals. So they say, look, go back and look at the treaties. These kinds of things can't actually be, these kinds of actions can't be heard in Japanese courts. So that's that's most of the cases. There have been a handful of cases, which I have outlined for you here, where the plaintiffs have actually won, and the Japanese courts have actually awarded some small amount of compensation. I say small by sort of American plaintiffs' lawyers' calculations in the hundreds or thousands of dollars range, right? Not the $1 million sort of jackpots that we think about here. But in most civil law countries, these kinds of damage awards are usually a lot smaller, and certainly in the case of Japan, whether it's forced labor, whether it was one of the comfort women decisions, or a poison gas decision, these damage awards have been in the hundreds of dollars or thousands of dollars range, right? So not huge, huge payoffs by any means. And when that's happened, as you can imagine, the defendants have appealed, and on appeal, they've all been overturned and said, sorry, see what I said up here, sovereign immunity, statute of limitations, all these things have, even if they won, let's say, at the trial level, they have been overturned at the appellate level, or a few of these have actually gone to the Supreme Court of Japan, where they have been dismissed as well. That gives you a sense of how these things have ended. There have been a couple of occasions where the companies, Mitsui and Mitsubishi, their heavy machinery departments have actually settled. So that represents another type of resolution here. But those have only taken place after a lawsuit has been filed, and usually after a court has exculpated the defendant for reasons we've talked about. And then there is some small amount of money that changes hands, and a very, very carefully worded statement to memorialize it. So usually the company doesn't say that they were legally at fault, doesn't say that they were legally liable. They're along the lines of some bad stuff happened, and to make up for it, we're giving a small amount of money, not compensation, not reparations, a small amount of money to these people for peace and harmony and things like that. So they're very carefully worded and do not accept legal and in some cases moral liability for the underlying acts. So this raises the question, why would you sue at all? So I can see for the first people in the 1990s who were bringing these that they might have thought they would have won. But for people who have filed these cases 3 years ago, 5 years ago, 10 years ago, you have a pretty long track record that says you're going to lose, right? So one of the questions we have is why go through with this in the first place? And so I've given you a couple of reasons there. But I think probably the most important one, or one of the most important ones, is look, human rights litigation, which is what we're talking about here, or public law litigation, which is what we're talking about here, doesn't operate by the sort of normal thinking processes or the rational actor model that we typically apply, or that scholars typically apply to litigation. So what do I mean by that? Well, let's first try to understand who the different parties to the lawsuit are, and try to understand what their motivations might be. So we have the victims, obviously, people from the war, Chinese comfort women, Korean slave laborers, what have you. What do they want? And of course, legally speaking, they want compensation, they want an apology. But there's also this idea of having your day in court and having the opportunity to confront your oppressor, right? So for a lot of these people, particularly the comfort women, they've lived in silence and had to repress their wartime experiences for 40, 50, sometimes 60 years, right? So this gives them an opportunity to come forward if they want to. Of course, no one's requiring that they file a lawsuit, but it gives them a chance, an opportunity, I would suggest, to publicly clear the air and to confront, if not the people themselves, the soldiers themselves who did this to them, at least the government, or in the case of corporations, the current leadership team, let's say, of the corporations that used their labor in the 1940s. So I think that's an important part of it. A second or third, I think, really important part, again, given what we've talked about, the denialism, which I'll turn to in a minute, but also the silence. This is a way of securing your place within public memory. And a lot, to go back to these the settlements I talked about, in a couple of those, they've actually required or requested that some kind of small-scale public sculpture or some small-scale museum is set up to commemorate this, right? Because these people feel that they've been forgotten, and now they've stepped forward, sometimes very bravely, and said, well, we want to make sure that our story here, our experiences, are not sort of swept away into historical oblivion. So I think for the victims, these are some of the reasons why they have decided to do this. For the lawyers, and let me just say a word about the lawyers here. They too, and particularly Japanese lawyers here, have played a really important role in this entire movement. So in a lot of cases, the lawyers themselves have gone to China to find victims. They've had to track them down. They've had to work with local Chinese political or legal bodies to find these victims, and they've often paid for the legal fees, right, the filing fees. They've often paid for the victims to fly to Japan to testify, and this is something that they have done out of their own pocket, or as we'll see, there have also been a number of civil society groups that have propped up or to support these different lawsuits as well. So again, lawyers, as lawyers in any country do, have their own political or ideological aspirations or reasons for doing what they do, and some of them are interested in trying to develop a human rights law or legal doctrines that can be used to protect people, whether it's victims from World War II or victims of rape in the current climate as well. And so lawsuits offer a way for them to reconfigure laws, to reconfigure treaties, to reinterpret Japan's treaty obligations or international legal obligations in a way that protects people, whether Japanese or foreign. A final group of actors here, as I said, are these civil society groups. Every time a new lawsuit is filed, there is a new sort of civil society group that pops up to support them. Usually call it something like the group to support the Chinese comfort women litigation, something like that. So there are activists, there are concerned people in Japan who want to make sure that the historical record here is accurate, and so they have also used and they've raised money to address and to bring some of these lawsuits in the first place. So one way to explain all of this post-war compensation litigation, I think, is to look at who the actors, who the supporters of it are. Let me touch briefly on some of the other things that litigation can do, and here I'm drawing on a long history of public law litigation scholarship in the United States, but also to a more limited extent in Japan. And let me talk a little bit about facts, right? Because this may be something that is particularly important in this political moment, but I think it's also really important to understand why plaintiffs in particular, and to some extent civil society groups in Japan as well, are so interested in litigation. So in Japan, I've talked about this a little bit already, there is, even to this day, a lot of denialism about Japan's role in the war. As I said, in the 70s and 80s, politicians flat out denied that the comfort woman existed. Since the lawsuits have come down and since courts have actually found, sometimes in quite stirring detail, what the nature of the policy was, document number 43 from cabinet decision in 1943 stated thus, these are now judicially found facts. And while I'm not saying that judges should be historians or judges are good historians necessarily, the fact that you have an official document, you have a judgment that says so-and-so happened, or Ms. Lee here was abducted at age 16 and brought to Shanghai where she served in a comfort station, that is now a fact that has been found in a Japanese judicial opinion under the first part of the opinion, which is called jijitsu, or facts, right? So it's harder to say, well, there were no comfort women or whatever it was, when you have a coordinate branch of government, namely a Japanese judge, saying the following are facts. And so I think one reason why litigation is helpful here is because it establishes facts and it helps counter some of these denial narratives that have come out of Japan and are still actually part of mainstream Japanese politicians' political discourse, right? So Now Japanese politicians no longer say, well, there were no comfort women. That line has changed over the past 25 years in response to a number of things. I would suggest these lawsuits, but also to investigations and reports that have come out from the United Nations, from the International Labor Organization, and others that have said Japan, and even members of our own Congress, have passed resolutions calling on the Japanese government to address and compensate the comfort women. Just to put a contemporary gloss on this, last year in 2016, let me back up a bit. Towards the end of 2015, you may have read about an agreement between Japan and South Korea to pay additional monies to Korean comfort women. They said, look, this is going to be the final resolution of this. We're going to pay this money, and the comfort women are going to stop talking about it. They're going to remove all these statutes. At the very end of my presentation, I have a statue. Let's see here. Oops. Oh, boy. So some of you may have seen this statue. And these statues have popped up both in the United States, in California, New Jersey, and Michigan, and also right outside the Japanese embassy in Seoul. Right? And this is a picture of a comfort woman, or a statue, I should say, of a comfort woman. And it's a way that South Koreans, both in South Korea and Korean-American advocacy groups or civil society groups, have said this memory continues. This memory lives on. So these statues have popped up both, as I said, in Seoul as well as in U.S. parks as well. So that's one way to make sure that these facts remain present and remain important in our world. So just to go back to 2015, there was this agreement. Supposedly that was going to resolve the comfort women issue between Japan and Korea for all time. Just a week after that, though, Abe, the man whom we began our presentation with, said, well, there are no documents that prove that the comfort women were forcibly taken. Right? So it's not the comfort women never existed. The current line is, well, we don't have any documents to show they were forcibly taken from their homes and then subjected to military slavery. So there's still a strain of denial. It's obviously very, very implausible now. It's also very highly contorted. No documents to show, no documents to confirm they were forcibly taken. But I think it shows you that there's still a fairly strong climate of denial even now in 2016, 2017. Let me see here. Again, there are a number of reasons, as we've talked about. I know many of you are lawyers, so I won't go into this in more detail. We can talk about it in the Q&A session, about the various reasons why you may want to file a lawsuit as opposed to seeking another route here. What else can trials do? What else does litigation do? People who have written about both Nuremberg and some of the other World War II litigation say, trials offer a process. Trials allow us to sort of set things in order. There's a beginning, there's a middle, there's an end. And this is a way of making sense of very serious or very complicated tragedies such as war. Trials allow us to sort of go through, find facts, adjudicate blame, allocate blame, and there's sort of I don't want to say a cathartic experience, but something that allows us to make sense of and attach a narrative to what can be obviously a very traumatic set of experiences. And again, as I've said before, the trial itself, for the particular victim himself or herself, it allows them to sort of reinsert themselves into history. A lot of this, as I said before, is about historical memory and the effacement of historical memory. And the trial and the opinion itself, when it comes out, says, actually, these things happened to Mr. Lee or Ms. Hyun or whatever it is. So this is a way of saying, yes, these things happened to you. The lawsuit is one official record that says, yes, we acknowledge that these things happened to you. Let me just talk very briefly about this issue of tort liability. So again, I talked about a couple of cases that were then overturned on appeal, but nevertheless, for that year or so, when they were considered valid judgments, were, I think, very important, for the cause itself. But when you go back and actually look at the way that they construct the violation, it's done very, very delicately. And this probably shouldn't be a huge surprise to those of us who work in the law, because we know that courts, certainly courts in the United States, courts in Japan as well, often duck the really sensitive or delicate questions. In this country, we have something called the political questions doctrine, which says that's too politically sensitive. We as courts are not going to wade into reviewing certain types of decisions that Congress makes or certain decisions that the president makes, because that would upset the balance of powers. And so similarly, in Japan, you have, again, judges or courts sitting in judgment of military actions, of decisions rendered in the 1940s. And so when, even in these cases where they found violations, they do so in very, very indirect or oblique ways. So there's one decision from 1998, perhaps the most famous decision in all of these, which actually found Japan liable and ordered the Japanese government to make a small amount of compensation available to certain comfort women. And the violation wasn't the fact that these women had been taken from their homes, raped 30 times a day for 4 years, whatever it was. It was that the current diet, so the Japanese diet sitting in Tokyo right now, failed to pass a law to compensate them. So that was the nature of the violation. Wasn't the stuff that happened during World War II. Rather, it was a present, and the term in Japanese is a legislative omission. Right? That's the kind of euphemistic term they use to describe what in many cases, or what many think to be a very, very important human rights decision, is coded or is framed in a very indirect, very anodyne way. So again, even though human rights advocates are very, very happy often about these results, I think from a rule of law or a human rights perspective, they're not the strongest or most robust vindications, let's say, of different human rights norms and ideas. We can skip the international law stuff to the very end. I will just add that in about 5 or 6 of these cases, that the Japanese judges have actually written legally non-binding, right? So they don't have any legal effect. But they're these little postscripts that say just how difficult it was for them as judges to handle this particular case. And they've said, look, this was an incredibly hard case to hear. Or they said, look, we hope the diet will continue its consideration of this, or we hope that the corporation, will continue to deliberate with the plaintiffs towards a better resolution of this than we here in court are able to provide. So again, that I think is interesting. Japanese judges very rarely include these kinds of postscripts to their judgments, but these series of lawsuits is when we've seen it 3 or 4 times, including one from the Supreme Court, which is even rarer. So again, what does all of this mean? Unlike what I began with the Holocaust litigation, we haven't seen that sort of global fund or global settlement. And I give the example here of the German Remembrance Fund that was, as I said earlier, started in 2000 to pay compensation and to recognize what had happened to many victims of the Holocaust, of World War II in Europe. What have the opinions done? Well, again, they recognized some of these facts, most of the facts, which helps refute some of the revisionist or denialist narratives that continue to spread around Japan. Even in those handful of cases where they've offered compensation, again, as I said before, they've offered monetary compensation, but not necessarily a strong defense of human rights. And then I'll just end with this, again, with a slide of this 16, 17-year-old girl, comfort woman, and that I'll end by saying I'm not sure that the prospects for reconciliation are any better now than they were even in 1990 when this litigation sort of first took off. We know a lot more about World War II through these things. The public has certainly been better informed about what happened 50 or 60 years ago, 70 years ago by now. Litigation has helped keep these issues alive, But as I said, it seems unlikely that we'll see a large-scale diplomatic reconciliation, diplomatic resolution, as we saw during the Clinton administration. So I'll stop there, and if you guys have questions or comments, my colleague Ray here has a microphone. I think we're being streamed live, so Ray would ask, and I would ask that you speak into the microphone so that our millions of viewers on YouTube can also hear your questions. Thank you.
You talk a little bit about your background and experience and how you got interested in this subject matter.
I love softballs. Thank you. So I studied Asian languages for 10 years and then said, well, what am I going to do with that? So I went to law school. This is sort of before the crisis where you could do that, and that was a viable career alternative. And so I wanted to study China and Japan and the legal systems. I then worked for a law firm, Morrison Foerster, in New York and in their Tokyo offices. Little known fact, Morrison Foerster represented many of the companies like Mitsui and Mitsubishi. And so when I first became interested in this project, as a law student, I sort of made a promise to myself that I'll continue to write about it, even as I drew a salary from a law firm that was representing the defendants here. That was sort of a promise to myself. And this project allowed me to go to Japan. I also work a lot on China and speak Chinese, and to go to China and to do research on the Chinese legal system and interact with Chinese lawyers and Japanese lawyers as well.
What is the legal significance of a nation like Japan giving an unconditional surrender? In that, does the nation itself unconditionally waive certain defenses or legal rights, or is that an issue?
Right. So the unconditional surrender was something that was orchestrated in the USS Missouri in either August or September of 1945, and Japan said, we will stop fighting, right? And so what then you have is the 1951 San Francisco Peace Treaty, at least as far as the U.S. and Japan is concerned. And it's the peace treaty itself, I think, is probably more legally significant. That's where they hash out who's going to get compensated for what kind of claims are going to be waived, and what claims are going to be, are going to continue to be valid. But I think throughout these processes, and again, this is not just true of World War II, this is true of a lot of post-war treaties, not a lot of thought went to the victims themselves. And again, there's reasons for that. In Korea, at least, the victims were actually part of Japan, right? Because Japan had colonized Korea, Japan had colonized Taiwan. And so neither of those countries were actually at the bargaining table because they were part of Japan at the time. And so what you've seen in the past 30 or 40 years is the rise of things like human rights litigation in this country, the rise of victims' rights or victim compensation in this country and in other countries as well, and an awareness, I think, that it's not just the states themselves, but it's actually the individual lives who are often the ones most affected by war. So the unconditional surrender, I think, was Japan's way of saying, okay, we give up, we'll stop, but these losses, so first you have the peace treaty that threshes out some of those legal claims, and then much later in the 90s and the 2000s, you have all this litigation still trying to dole out who is legally accountable or who is legally liable for what. And again, that process, I think, is still an ongoing one. And the courts in Japan have proven or have said now repeatedly what they're willing to do. Other jurisdictions' courts have different responses and different thresholds, let's say, for allowing compensation or reparation. Yeah.
Yes, since you brought up in your presentation the statute of limitations, I would like to know, since these are basically in Japan and in Germany crimes against humanity, what is the status of the statute of limitations as it regards crimes against humanity?
Excellent. Yeah, great question. So in this country, there's a case called U.S. versus Prince, which is also about World War II. And there you have the idea sort of first floated, not first floated, but first kind of recognized by a court that there is no statute of limitations for crimes against humanity. And that's a line, that's an idea that is often repeated by academics, by activists, by people who want sort of a friendlier or more human rights friendly attitude to prevail. But very, very few courts have actually recognized that. Right? So I can say in my human rights class that there is no statute of limitations for crimes against humanity, but I have yet to find a court that's going to say yes, and so we agree to that, and we're going to allow claims that are 70 plus years old to be heard and to allow compensation for. So that's an idea that I think academics and lawyers, human rights lawyers, are fond of making, but I have yet to see a court that's actually willing to rule on that and say, yes, as a matter of law, there is no statute of limitations for crimes against humanity. Yeah, that's a great question. Yeah.
Thank you for a very interesting presentation this morning. As to the question of standing and legal personality, has the Japanese government since 1945 in essence argued all those bad things were done by the Empire of Japan, and there is no Empire of Japan anymore? We're now a constitutional monarchy, we're a modern democracy, and so forth. So we're not legally responsible for all the terrible things done by the predecessor government.
Yeah, that is normally how these things are framed. The sovereign immunity doctrine in particular, they say, well, look, we can't apply. So if the Japanese government, the one that has been in place since 1946 forward with the new 1946 Constitution, there they say, well, look, we have a constitution that respects human rights. We have, as I mentioned, the state compensation law from 1948 that specifically provides for the government to pay compensation in these following cases. But the stuff we're talking about now happened before that time. And so what we have to do is look at the status of law, whether it's domestic law, international law, in the 30s and 40s, and apply that law. And so the line for there is sovereign immunity was, and again, there's still some debate about the exact contours of sovereign immunity. The cases in Japan, at least from the 20s and 30s, where they've applied sovereign immunity, apply to things like there was a fireman and was doing an exercise and damaged somebody's property, right? So because we have sovereign immunity, we can't hold the state accountable for that kind of negligent act where a fireman broke down somebody's house or something like that. But it's a completely different issue whether you have sovereign immunity for things like comfort women, right? That are known violations of law. Obviously, there's no cases from Japan that apply the sovereign immunity doctrine from the 30s and 40s that would hold that kind of, or hold the state accountable. But what they've said is, or at least the courts have said is, look, sovereign immunity, our post-war government, doesn't have such a strong line on it, doesn't have that particular interpretation of it. But the pre-war, the Meiji era, or the early Showa era, is one where sovereign immunity was essentially absolute, and so we can't now go back and change 1930s, 1940s law. But yeah, that's how current Japanese courts have reviewed the legal environment of the 30s and 40s. Yeah. Other questions? Comments? Everyone's thinking about the baseball game, I can tell. All right, well, thank you guys for coming. If you have any questions, feel free to come up afterwards. I'd love to talk to you. And thank you for coming, and enjoy your 90-degree weather today.